We are standing at the edge of something the country has never experienced before. A moment that legal experts have warned about for generations, but always assumed would remain theoretical until now. Late this afternoon, a revelation surfaced that has shaken the foundations of American trust in its institutions. And while major networks are choosing careful language, avoiding direct statements, the implications are impossible to ignore. What emerged today was evidence suggesting that a powerful figure inside the judicial system may have crossed a line so serious that it threatens the legitimacy of the entire process. Not rumors, not anonymous chatter, but a recorded communication allegedly captured during a lawful federal investigation that raises deeply disturbing questions about influence, power, and corruption. If this information is verified, it would represent a scenario more severe than any ethics controversy in modern judicial history. This is not about gifts, vacations, or undisclosed relationships. This is about the possibility that a legal outcome itself was treated like a commodity, a transaction, an exchange of value for influence. Think about what that means for a moment. The authority of the court does not come from force. It does not come from money. It comes from belief, the belief that decisions are made based on law, not leverage. The moment that belief cracks, the entire structure starts to tremble. Legal analysts have long described this as the nightmare scenario, a situation where even one decision becomes suspect, where every narrow ruling must be re-examined, where confidence collapses not just in one individual, but in the system as a whole. Once doubt enters the equation, it spreads fast. History offers very few comparisons. Decades ago, there was a case involving a justice whose financial entanglements raised serious ethical questions. That episode ended quietly, with resignation before impeachment. But even then, there was no recording, no explicit discussion, no clear exchange. What we are talking about here is fundamentally different. This is not about appearance, it is about mechanism. According to summaries circulating among lawmakers, the recording was not even intentional. It was reportedly captured incidentally during an unrelated investigation. That detail alone has stunned legal observers. Because when investigators encounter material involving high-level officials, protocol usually demands minimization, silence, protection of the institution. But this time, the content was allegedly so explicit that it could not be ignored. Investigators faced a choice: suppress it and become complicit, or elevate it and trigger a constitutional earthquake. They chose the second option. Now everything accelerates. Lawmakers are scrambling. Meetings are being canceled. Flights are being rebooked. Behind closed doors, conversations are happening that will define the next chapter of American history. Because the process, once started, cannot simply be stopped. Under the Constitution, the mechanism is clear. The lower chamber investigates and drafts charges. The upper chamber decides removal. The threshold is intentionally high, and in today's polarized environment, agreement on anything is rare. But certain evidence changes equations. Some lines once crossed leave no room for loyalty or spin. Meanwhile, another battle is already forming. The defense is predictable and very modern. Claims of fabrication, claims of artificial intelligence, claims that nothing can be trusted anymore. Welcome to the 21st century, where truth itself must be authenticated frame by frame. Experts will analyze frequencies, voice patterns, ambient noise. It will be science versus skepticism. And while that plays out, the institution remains frozen. Cases stack up, decisions stall, confidence drains away. Imagine a ruling released tomorrow under this cloud. Would states follow it? Would lower courts enforce it? Authority only works when people accept it, and acceptance is built on trust. The political consequences are just as explosive. Elections loom, appointments hang in the balance. Markets react faster than voters ever do. Money moves before speeches are written. Pay attention to that. Markets often signal reality before headlines catch up. There is also the most dangerous outcome of all. Stalemate, no resignation, no conviction. A figure who remains in position while half the country believes the system has failed. That is how institutions decay, slowly, publicly, and painfully. Centuries ago, lawmakers decided judges should not be removed for opinions, only for crimes. That standard has held for over 200 years. If it fails now, the precedent collapses with it. This is no longer about ideology. It is not left versus right. It is about whether the rule of law is real or performative, whether power answers to accountability or shields itself behind tradition. In the coming days, watch 3 things closely. Watch whether an independent investigator is appointed. Watch whether internal pressure emerges from within the institution itself. And watch the economic signals. They will tell you what insiders believe is coming next. This moment will be studied for decades, not because of one individual, but because of what the system chose to do when tested. Did it correct itself, or did it protect itself? The answer to that question will define the future of American justice. Stay aware, stay critical, and demand transparency, because once trust is lost, no ruling can restore it.